if they've, say, written a cheque and paid it in the other, or they've somehow tries to disguise the transfer by putting the combined spreadsheet together, we can spot that more easily. Funds going across. And basically, what we ultimately achieve is the end result of a combined pivot for as many accounts as you've got for the full period. And there's just an example of, you can have a pile of paper that you would never be able to sort of like sift through or get any detailed analysis, or you can ultimately have the pivot table that's there as a glance and you are able to drill down and get each and every transaction that falls into that total. And this could be thousands and thousands of lines of an Excel that we can summarise quite quickly. This obviously helps. We do this as a matter of routine on a lot of cases that come in, and certainly a lot of POCA cases where it will be that somebody has gone through 6 years worth of bank accounts and listed every single penny of credit into that account, unknown credits, let's say cash credits, and put them in as assumed benefit. So we are able to check that straight away, and often there's errors in there. And then obviously we can produce that list and see if there is genuine income involved in that, and drop that down, ultimately reducing the assumed benefit amount. We do this within our reports, but what we've also done as well for a handful of solicitors is if they are they don't want us to do a full forensic accountancy report to respond to the section 16, they're quite happy, it might be relatively straightforward, and we've got some solicitors who are POCA experts and quite happy to put in their own defence or their own section 17. But if there is a high volume of bank statements, then we will just do this processing element for them. So it takes some of the sort of like hard, the laborious work out of it. We can do that as like a standalone project and just give them the figures back for them to then drop in their report. So it can be used both ways if that is useful for anybody. That's it for me, unless anybody's got any questions.
Emma, can I jump in and ask a question? Going back to the pivot table. Yes. Where you've got a figure of, let's say, cash deposits over the period of £15,703.10, can you break that down? Yes, absolutely. Yeah, so everything in your pivot table, it is just literally 2 clicks. If you've got a pivot table, for anybody who isn't familiar with a pivot table, you have a total on the actual table itself, and just literally by a double click on that, it will give you the list that makes up that total. So if there's 100 transactions that makes up that total of 15,000, for example, you instantly are able to get that full list of transactions that makes up that amount. It's just a working list to sort of either glance at or to respond to or to work away at. Yeah. Thank you. Anybody else? Right, I think if I'm done, I will hand over to David. Right, I will jump in with section 10A. Now I shall try and share screen and see if this works. Right, do you see, hopefully, a heading that says section 10? Great. Well, section 10 was introduced in 2015, section 10A, I should say, was introduced in 2015 as a simplification to POCA and to help make it easier and simpler.
David, we've lost you a little bit vocally. Oh, that's better.
Okay, can you hear me now? Can you hear me?
Yes.
Good, yeah. Good. Right, so yes, so section 10A was introduced in 2015 to make things simpler and quicker to deal with the recovery of assets and the paying off of confiscation orders. And as often happens when things are made simpler and quicker, they actually get more complicated and more difficult, but such is life. So let's first of all consider the basics of Section 10A. We're dealing here with property held, at least in part, by the defendant. It must be an asset in which the defendant has some interest. And it is one that is likely to be realised or used in some other way to satisfy ultimately the confiscation order that's going to be made. That's what Section 10A is driven at. Under Section 10A, the court determines the defendant's interest. Although we talk about Section 10A in terms of third parties, actually Section 10A itself is directed towards the defendant's interest in the property that we're considering. But in doing that, the court must give an interested third party a reasonable opportunity to make representations. Now, one of the things about Section 10A is that we need to be aware that actually the court can proceed and complete a confiscation without applying Section 10A at all. So that we may be in a situation where, say, straightforward situation, husband and wife own the matrimonial home, the land registry title is in both their names, and the court may consider that each of them has 50% of the equity. Well, the court can make that decision that each of them has 50% of the equity and make a decision about the defendant's available amount and make the confiscation order without invoking Section 10A at all. So just because we have a situation where property is held by the defendant and somebody else, it doesn't necessarily follow that the court is going to be required to make a Section 10A determination. What it can do is simply make a decision, make a finding that in the example I gave, this defendant has 50% of the equity and that's it. And that doesn't use the mechanism of Section 10A.
David, sorry, can I ask a question at this juncture?
Yes, of course.
Isn't there a contradiction there? Because the Supreme Court case of Hilton says that Section 10A should only be used in simple and straightforward cases. And that is a simple and straightforward case. So why not use it?
The court can use it. All I'm saying is the court is not obliged to use it. And I think the Hilton case was one in which there was an appeal, if you like, against the Section 10A determination, if it's the case I'm thinking of.
Yeah.
The Supreme Court said, well, actually, there hasn't been a Section 10A determination.
Yeah.
The court has simply said, well, this is the situation and we're going to proceed on that basis. Yeah. And because it didn't make a Section 10A determination, it wasn't required to go through the Section 10A process of giving the interested third party a reasonable opportunity to make representation. Right. So yeah, Section 10A is, there is a bit of a contradiction in terms there, isn't there? By saying, yes, it should only be used in simple cases, and in simple cases, we don't need to use it.
Yes, that's the contradiction. That's the contradiction.
That's the contradiction, yes.
So in the contra position is in more difficult cases, you don't use it.
Yes, because you're dealing with a Crown Court and not a High Court proceeding. And you may be having a Crown Court judge who is not well versed in property law or trust law or family law. And in difficult circumstances, say we've got a situation where the defendant owned a property before he got married, or perhaps a female owned a property before she got married, gets married, subsequently convicted of something subject to confiscation under POCA. I've had AFIs say to me, well, it's half and half because they're married. That's the law. Well, it isn't that straightforward. If you've got property that was owned pre-marriage, it's a bit more complicated than that. And I think that what the point that's being made about Section 10A is we shouldn't ask Crown Court judges to dabble in family law and property law and trust law if actually they're not in a position to do that. and perhaps even counsel is not well versed in those areas of law.
Because
so, yes.
also there are often concurrent proceedings, aren't there? Be they matrimonial or be they someone wanting to recover their interest in the property at the same time.
Yes, yes, indeed.
And those are the experts in the field, not
yes.
His Honour Judge Bloggs at Bloggs Crown Court, who did a bit of property 45 years ago.
Yes, and sometimes you see the confiscation proceedings adjourned and adjourned and adjourned and adjourned so that the family court can sort things out.
Can I just ask one quick question there? If they're adjourned and adjourned and adjourned, what happens to your 2-year limit?
We'll come to that. Can I file that one for its time? Yeah, I will come to that. Yeah. Okay, so Section 10A. One of the problems with Section 10A is that there's no legal aid for a third party who wants to be represented in confiscation proceedings. And yet the
sorry, David, there is, but you get it. It's civil legal aid.
Oh, okay.
Bizarrely, I've been instructed in a case recently, and it's a civil legal aid order you have to apply for.
Right.
And we've got it, but there is no criminal legal aid.
Right. Yeah. Okay. Yeah. Okay. I'll take that. There's no criminal legal aid for third party. The determination, once it's been made, is likely to be regarded as conclusive, although it is subject to appeal. And there is, if you get into appeal, we start talking about serious risk of injustice and so on, and things get all a bit grayer. There is a risk in confiscation proceedings that if the third party has an interest, the allegation may be made that that interest has been acquired as a tainted gift from the defendant. And I'm thinking, for example, of the case of Hayes, where the wife was claiming a 50% interest in the equity in the property, and it kind of rebounded in that the court was looking then at whether that was a tainted gift that she'd received. And being a tainted gift, if it is a tainted gift, then two things happen. One is that it's added into the available amount of the defendant as if that gift hadn't been made. That's not strictly correct because there's valuation procedures and so on and so on. But the effect is that the tainted gift does not divest the defendant of that property in terms of his available amount computation. And the other thing is that any property owned by the recipient of a tainted gift can be recoverable property in confiscation. So actually, having the spouse, let's say, having an interest by way of tainted gift is probably worse as an outcome than the spouse having no interest at all. Or again, you can get into issues as to whether the third party holds simply as nominee for the defendant. And one of the difficulties we get to is in families, particularly in some cultures, you may find family members saying, well, actually, Uncle so-and-so owns all the properties that all the family live in on paper, but he's not the beneficial owner. They're simply held in his name because that's the way we do things in our culture. And also, there can be all sorts of difficulties caused by restraint orders, just practical difficulties in terms of realising properties and so on when there's a restraint order. So Section 10A isn't an easy way to make things simple. I would say from the point of view of the defendant's solicitor, he or she needs to ensure that the third parties are notified if there's a Section 10A application. Now, the prosecution ought to notify the third parties where there's going to be a Section 10A application, but, you know, better safe than sorry, get them notified. And there is a risk of a conflict of interest if you are acting for a defendant and the third party, or even if you're acting for the defendant and more than one third party. and there have been some rather sad cases before the Court of Appeal